So, a very good morning to all of you. So, for death penalty, we discussed something yesterday. We discussed about section 302 of IPC, right? We discussed about rarest of the rare doctrine also. We discussed about UNGA resolution of 2007. On the basis of this, United Nations General Assembly resolution, बताया था बस, United Nations General Assembly resolution was there that for all the countries, death penalty should have what is called as moratorium. Means just keep it on hold for every case. You need not to give death penalty to any of the person, means any person for any crime. But that the India did not put moratorium. India did not give vote in favor for this UNGA resolution. But yes, around 135 countries today have no death penalty in their country. But contrary to this, in India there are states which gives reward for the public prosecutors. The public prosecutors are those who are lawyer from government side, that come what may, the person should get death penalty. So if 1000 point from 0 to 100 scale, if 1000 point is to be given to a lawyer for a case, 1000 points will be given if death penalty has been ensured by giving good bet in the court for a case. So this state is Madhya Pradesh, and the person who has scored less than 500 is given a warning. 500 is for life imprisonment. So at least you have to ensure life imprisonment but as a public prosecutor for some of the deserving cases. Deserving cases matlab means the person who has done some heinous crime in that sense. Okay. And below that the kind of civil offenses and like that. And 2018 was that year in India which crossed the level of year 2000, wherein less than 100 death penalties were awarded by the session courts in total. In 2018, around more than 150 death penalties were awarded. It is another case that Supreme Court is there to convert it into life imprisonment or putting it on hold. Apart from Article 72, which is for mercy petition, means after death penalty the person will be approaching the president. The review petition, the curative petition is also there. Curative means C-U-R-A-T-I-V-E, means cure, to cure, C-U-R-E, to treat the already decided case. for some of the new fact added to the case. Okay. Then apart from this, Article 134 was also allowed. What is Article 34? I have already discussed it with you, along with Article 133. Appellate jurisdiction, appeal jurisdiction. Appellate means the lower court decision can be appealed against in the higher court, Supreme Court being on the top, right? So Supreme Court can hear such appeals for or against the death penalty. Okay. Then there was a PIL filed in 2020, sorry, or 19, that the hanging method should be changed to some other method like lethal injection, gas chamber, and poison. But center has given reply to the court, because on the basis of PIL, court asked the center that do we have certain other replacement methods to give death penalty to the person, because in PIL the scientifically discovered time period was 40 minutes for a person to die, when means entire process takes 40 minutes time. Not hanging, in entire process. Entire process means after hanging the person is brought out of the loop and the doctor is checking the pulse and the doctor is finally declaring the person dead. Okay, so it takes 40 minutes process. So it can be reduced to at least 5 minutes. 5 minutes. So there is a human right, and human right is all about dignity. So it is Article 21 which provide right to die and right to life. So right to die with dignity also, and right to take my soul, that too with a kind of derogatory way should not be there. It should be justified way. And also, if not only my physiological health but my psychological health will also be okay when I am being hanged. So as a prisoner or as a convicted person yet to be executed, I have all the rights to consult the doctor, psychologist, human right activist, apart from the family member. Family people must be informed 14 days prior to the hanging. 14 days, 1-4. This is a process. In case of Bhagat Singh, these all protocols were violated, and these protocols are of British India, that we are following it. And the person who hanged is belonging to only one family. I am forgetting the name of a family. So the family member of that family are given government job and they hang the person. And they say something in the ear. It is a discretion of the person. Doctor, police authority may not come to know that what he has said in the ear of the person being hanged. It is a convention. Yeah. Yeah, it is so. Because so you will be applying that, okay, I am also fit to do this work. Okay, so that way. नहीं तो मार. So it's all about a private vehicle gave a dent. Means you had an accident and private vehicle involved in that. so nothing will happen. But if that vehicle is of Prime Minister, then you will make you and cry, no, I want IAS post against this. Nothing less than that, otherwise Mr. Prime Minister, I will not see you. Because कहीं ना कहीं से तो फंसे वो, means somewhere down the line you have a trap for that person. Yes or no? So you understand, hierarchy is hierarchy. If we are driving a vehicle and a poor person has seen, so one will try to make the mileage out of that accident, yes or no? So we will be doing the same. That's how it is. So when it comes to the fact that if the police authority, the government authority has done some mistake, then there is a compensation, because you are a wisdomful person, not unmindful of your actions, right? So that's how it is. So legally trained person committing some mistake means, what about the other person? Then there is no question. Okay. So this is the case, and Madhya Pradesh is the state in India which is giving most of the death penalties. It's not simple. It's just like that. If the reported case are forwarded in that sense, and the court is also hearing it and giving death penalty, not even the court, tribunals can also give, right? So that way, if it is so, then death penalties will be counted. It is another case that appeal or the other courts are revising such verdict. Yes, to just mention some of the extraordinary things in your answer. I have sent the document. It might have not been sent to you, forwarded to you. 3-4 page document for death penalty, it will be given. Okay. So no improvement in this 1000 point wala. No, nothing has happened. Nothing has happened. And the reports are also prepared by the NLU people, National Law University. So they prepared that report. Maybe it is having the most of the tribals, and one of the state was carved out of it in year 2000, Chhattisgarh. So that may be a reason. And Chhattisgarh is having red corridor also. So maybe the Chhattisgarh cases might have been reported here in Madhya Pradesh. Okay. So can we write one line about death penalty? In gas chamber, certain poisonous gases are released. Result. So center has told that we don't have any other method as of now, and one of the experiment was done by giving the lethal injection to a person, but the person did not die. that center has reported back to the court. You will read the document I've sent, so you will come to know. Concentration camp had many of the brutal methods to kill the people. Yeah, electrocution means electricity. Hmm? Hmm? Euthanasia. Euthanasia. Euthanasia is mercy killing. Euthanasia is a totally different case altogether. If the person is terminally ill, cannot be retrieved back to its normal life, the medical expenses cannot be, met. So the doctor is allowing passive euthanasia, that the life support system will be withdrawn and the person will be allowed to die natural death. There is another way of killing the person by giving injection, that is active euthanasia, so the person is not suffering. It is not allowed in India because of deliberate reason that old people, the young generation doesn't want them, the generation don't want them, and the property is the main thing, and if they are allowed to die their natural death, they will be giving property to the person whom they like, and it may not be necessary that they are real son or daughter. Yes or no? So it will, this process will be exploited by the young generation, active euthanasia. It is the apparent reason 90% of the cases. If you look at the millionaire and billionaires people, it happens like this. So there is a family feud, family dispute for property reasons, brother fighting with each other, tissue. Everywhere 90% of the cases, right? So it's like that. Life is having its own psychological dimensions. At some age some hormones start developing they will take you to more practical side of the stories, not the emotional side. So that's how it is. Okay, so we can write one line about it. Section 302 of IPC prescribe death penalty as an alternative punishment for murder murders. We'll stop. Around 135 countries have either abolished or have not practiced death penalty in law as it being inhuman, but many countries including India and USA have retained it as a form of punishment for murder and other heinous crime. HEINOUS, heinous crime. Next paragraph. Judiciary in Jagmohan case 1973, JAGMOHAN, Jagmohan case 1973, held that entire procedure for criminal trial under CRPC, CRPC means Criminal Procedure Code, CRPC, for arriving at death sentence is valid, comma, then imposition of DP means death penalty is not prohibited under the Constitution. Full stop. Therefore, DP is not unconstitutional in India. Article 21 and Article 29 are also not violated are also not violated by death penalty. As Article 21 recognize right of state 21 recognize right of state to deprive a person of his life and liberty in accordance with fair fair, just just and reasonable procedure established by law. We'll stop further. Article 72 and Article 161 provides for power of clemency, CLEMENCY, clemency through mercy petition to be exercised by President and Governor. Further, Article 134 provides for appeal against death penalty sentence up till Supreme Court. Right. It is argued that DP is prescribed as a punishment only for heinous crime. So DP, heinous, HEINOUS, heinous crime, HEINIOUS, heinous crime. So DP is only an exception, and life imprisonment is the rule. Right. We'll stop. DP is awarded only in rarest of the rare cases where murder has been committed in a diabolical, DIABOLICAL, diabolical manner without any sense of remorse, REMOURSE, sense of remorse. Next paragraph. On the other hand, it is argued that DP is inhuman and cruel form of punishment and it is against human civilization. Civilization. Further, criminal justice system, criminal justice system should be based on reformative principle, should be based on a reformative principle, but not on retributive principle, but not on retributive, R-E-T-R-I-B-U-T-I-V-E, retributive principle. Full stop. Capital punishment also tend to, T-E-N-D-S, tends to be discriminative to the poor and vulnerable section, to the poor and vulnerable section of society, such as ethnic minority and migrant labor. Migration wala migrant, M-I-G-R-A-N-T, migrant labor. Let's talk further. If an innocent person is punished with DP and subsequently means later on, SUBSEQUENTLY, subsequently his innocence is proved, then no justice can be done to him. No justice can be done to him. Full stop. It is also false to argue that DP act as deterrent means prohibitive, act as deterrent against murder. Number. Statistics, data. Stats shows that DP has no impact on curbing, C-U-R-B-I-N-G, curbing heinous crime in a country. Therefore, DP may be constitutional in India, but it lacks moral strength and it should be abolished. UNGA, United Nations General Assembly, UNGA, in October 2007 passed a resolution calling on member countries to impose moratorium on DP as a first step towards towards abolishing abolition of DP throughout the country. DP throughout the country. Right, then right below this for prelims right here, number 1, section 121, under IPC is for waging war against Indian government. Waging, W-A-G-I-N-G, waging means having or going for. Waging war against Indian government, comma, section 132 for abating mutiny, A-B-E-T-T-I-N-G, abating mutiny, M-U-T-I-N-Y. Mutiny means armed force revolt or kind of protest within the army. Mutiny. Then section 194 for giving false evidence contributing in death penalty. Then comma, section 305 for abatement of suicide, means encouraging or tending or motivating a person to suicide indirectly. Abatement of suicide of a minor. Then comma, section 396 for dacoity, D-A-C-O-I-T-Y. Dacoity means kind of robbery. Dacoity with murder, D-A-C-O-I-T-Y. Dacoity with murder. And section 307 attempt to murder, by a convicted person for life imprisonment. Life imprisonment. Right. Then second point, NLU, National Law University, has published a report wherein it has been shown that in 2018 the highest number of DP, that is 162, have been awarded. MP being the highest contributor in it. MP being the highest contributor in it. Madhya Pradesh being the highest contributor in it. In MP, titles like Best Prosecutor of the Month, comma, Pride of Prosecution are given are given on earning 2000 points, 2000 point out of a scale from 0 to 1000, 0 to 1000, wherein thousands point are given for 1 dp, thousands point are given for 1 dp, and 500 points for 1 life imprisonment. Life imprisonment. The next point, a PIL was filed in court for changing the method hanging method which is practiced under CRPC section 354 clause 5, which is practiced under section 354 clause 5 of CRPC, means Criminal Procedure Code. Pledged of the court had asked the center but center has denied any change in it, as no better alternative is possible. We'll stop. Notably, hanging takes 40 minutes. Notably, hanging takes 40 minutes process to declare a prisoner dead. Which goes against spirit of Article 21, that is right to die with dignity. Perhaps lethal injection, shooting, gas chamber, or electrocution are the alternative. Okay. And next point, doctrine of rarest of the rare. Doctrine of rarest of the rare was given by Supreme Court in Bachchan Singh case, in Bachchan, Bachan, Bachchan Singh case. Which is about two questions. Number one, is something uncommon about the crime? Number two, no alternative punishment but only death penalty is possible, but only death penalty can be given. Okay. Yes, it can make. Yeah. Prosecutor is the one who is a government side lawyer. गवर्नमेंट साइड लॉयर जज बनने के काम आता है क्रिमिनल साइड जज assessment when there is a panel. Bar Council of India is there which represent all the lawyers, so one is to be appointed as judge on the basis of minimum experience, being you are practicing as a lawyer, right? And 90% of the judges in High Court and Supreme Court are lawyers, not the people who came through exam. They are there in the district court, settled there only. Article 29 in 19. Yeah. Article 19 clause 1 subclause A talks about freedom of speech and expression. So this expression includes death penalty. Okay. Probably a question may be there in prelims. When you read it again, whatever the noting is, you will develop a sense of inclination towards towards or against, right? So that sense tells about your stand that you have taken, right, for a question. Okay, so this is only the possible way perhaps for UPSC at least. No direct way, only diplomacy. Definitely. No, it is not death penalty. Encounter is it is a offshoot of a process. Encounter is an offshoot of process. So encounter is not done with the intention to kill the person. Encounter, you understand? You are countering someone from committing some future crime. Future crime may include killing you also, means person is killing you, so it may be self-defense. You are killing other person or you tend to kill other person, then also encounter. So in encounter, people if they are dying, then also it is an exception. But it is not that the intention is to kill the person in encounter. But in encounter, the permission to liberal firing is ordered. Encounter is never done with the intention to kill the person. Where it is written? Where it is written? So, हकीकत में तो actually most of the encounters are fake encounters. Most of the encounters are fake encounters. You understood? Fake encounters. So types of majority you know very well. All the majorities. तीन types पता है. So there is a question of prelims. Should I frame the question or after the topic is over I should frame the question? Oh. Okay, just for inquisitiveness, for the minds with all satanic flavor, consider the following. Statement number 1. President impeachment require an exceptional and exclusive majority. Number two, presiding officers in legislative houses can be removed by what is called as effective majority. Then number three, creation of legislative council require a special majority in legislative assembly. Disapproval of national emergency under Article 352 by S require simple majority. So you have to tell the correct answer. A, B, C, D. All are correct, none correct. So this is not a question. Which one is wrong? So all are wrong, all are, none is wrong, one or two wrong, three wrong, E option, three and four wrong. Easy question. Hmm. बोलो जी. Hmm. Wrong. Which one is wrong out of this? So see, exceptional and exclusive majority, then something called as effective majority, then special majority, then simple majority, right? So four types of majority are there in front of you. Though here the is answer is D only, because it requires simple majority. No, creation of legislative assembly require special majority. No. I was in the wrong impression. So basically the answer is none. It means all are correct. Answer is B. स्पेशल मेजोरिटी चाहिए, पार्लियामेंट में सिंपल मेजोरिटी चाहिए, इन लेजिस्लेटिव असेंबली स्पेशल मेजोरिटी इज रिक्वायर्ड. So that is what I am saying. President impeachment require an exceptional and exclusive majority. Exceptional why? Because such majority is not required anywhere else in the constitution. It is required only in one case, that is to impeach the president. That's it. It's the toughest one. So let's understand it here. किसमें? No, to introduce 10% of the MPs. 10% of the MPs means the present and voting. That's required. और minimum भी मान के चले तो 55 in Lok Sabha. Introduction, if they give in writing, then they will be passing it with the simplest format to disapprove it. But when it comes to approving something not desirable, it requires higher number of MPs. So the special majority will be required. There is another question, there is a catch. So let's understand it here. So something is called as simple majority. Simple majority. So for time being, we just consider the composition here. Let's see, in Lok Sabha as of now 543 members are there. Okay. And in Rajya Sabha we have 245 members and there is president. Okay. So any bill is coming in the house apart from the joint sitting under article 108, which is another different scenario. Every bill has to be passed in each of the house independently, separately. Simple majority means half of present and voting. Half of present and voting. So half of present and voting, simply we can understand that 450 were present on a fine day in Lok Sabha, but only 420 voted. 30 were abstaining from voting. Abstaining means I am not expressing in favor or against, or I am going to canteen to eat, or I am outside, or I am sleeping. It is also a possible case. Yes or no? In Lok Sabha or Rajya Sabha, if you sleep, then what is the problem? No problem. There was a picture in media that a person was sleeping. I don't know. The person was Arun Jaitley ji or okay. Oh. Okay. Chota Bheem. Not a surprise. So much of money. I don't know why the person is after the power only. What is hidden in power? Enjoy the life. One has to settle down also. One is not worried about that fact. Blind about the power. Anyway, coming back. So present and voting means the person who is present doesn't matter. The person who is present as well as voting matters. So here what shall we be doing? Half of 420 means 201. The minimum number in simple majority can be 55. Why? Because minimum 1/10 of parliamentarians or the members of the house required. Otherwise there will be what is called as quorum. Quorum. Session cannot be held. Right? So that's how it is. Now if we talk about the effective majority, effective majority means half of the effective strength. Half of effective strength. Effective strength means total strength minus vacant seat. Vacant seat on account of sickness, death or resignation or otherwise. Death, sickness, resignation or otherwise the seat is falling vacant. By-elections will be held. Till then the seat is vacant. So for example, out of 43, 13 seats are falling vacant. So the effective strength is 530. Understood? So what is the answer? 265. Now this effective, yes, plus 1 is there in every case. Plus 1 is there in every case. In every majority plus 1 is required. Plus 1 because 50-50. Plus 1 means 1 has to be some point ahead of the half. Means if the house is divided, then there is a deadlock. Means out of 10, 5 people are saying we will go this way, 5 people are saying we will go this way. So then 1 plus 1 is required, that proposition, to be on one side. So what if the half of the things are there in the Lok Sabha? Then there is a casting vote of the presiding officer. Casting vote of the presiding officer. So either of the side, it has to be 49 or 51. If it is 50 or 50, then a speaker will be there coming in picture. And if the speaker is saying I will go this side, then other side will be winning. Okay? Yeah. Sickness, death, resignation or otherwise. Otherwise, so sickness means sickness may include terminally ill person in comma, so like that. Otherwise vacancy नहीं मानी जाएगी till the time doctor is saying that the person is not able to join back. Okay. Now this effective strength is used only for removing the presiding officers. Now presiding officers include a speaker. A speaker nomenclature is used for Lok Sabha and for Vidhan Sabha. Then deputy speaker. Deputy speakers are also there in Lok Sabha and Vidhan Sabha. Then the effective majority is also used for the deputy chairperson of Rajya Sabha as well as Legislative Council. Then the chairperson of Rajya Sabha Who is who? Vice President. And the Legislative Council. In Legislative Council, MLC, Member of Legislative Council, become the chairperson. But in case of Rajya Sabha, it is Vice President who is the chairperson. Effective majority. But effective majority is used in case of Vice President in Rajya Sabha. And Lok Sabha agree to it by simple majority. Because one is monitor of this class. So this class will be removing a monitor. Monitor means presiding officer. Presiding officer means the speaker or the chairperson or deputy as the house is. Yes. Understood? यहाँ तक की बात समझ में आई? Clear? Now, there is something called as absolute majority. Absolute majority. This absolute majority is half of total strength of the house. Half of total strength of the house. Half of total strength of the house means what? 543 here or 245 here, no other number. It means into 543. So how much? 272 in round figure, approx, right? 272. Or in case of Rajya Sabha, approx 123. Okay, 123. Now this strength is nowhere required. Nowhere required independently. Nowhere required independently means in association with some other majority it may be exercised. Did you understand? Absolute majority is not required or is not used in any of the process in Indian democracy, in Indian parliament independently, the way effective majority or simple majority is used. You are getting the point? Then what did I say? That independently only it is not used, but in association with some other majority is used. Now in association with some other majority, we have fourth type of majority called as special majority. Now in special majority there are two types. Special majority there are two types. What are those two types? We make it three types of special majority. Yeah. अच्छा और so the special majority, number one, 2/3 of present and voting. 2/3 of present and voting. This is first type of special majority. Now in this the number will be, you have the same number here, present and voting, how many? 420. So we have it here. 2 by 3rd into 420. How much? 840 divided by 3. Yes? 280? Yes or no? Here the number was 210. Here the number is 280. Now, second type of spatial majority is 2 by 3rd present and voting, which should be more than or equal to half of total strength of the house. Now also I just forgot that, okay, if this majority is there, independently it is used at any of the place in parliament. This first. No. There's a catch. In books also it is not there, but I am telling it. This is not the majority which is required in the constitutional amendment. Only in 2 cases it is required. What are those 2 cases? Article 249 and Article 312. Article 249, when 2 or more state request to make a law for them, and the law is to be made by whom? The parliament. So you are one state, I am one state. A truck we cannot go from this state to that state, because on border you have certain taxes, but the tax rate is very high. We are not able to reach a consensus, right? So we will be going to the big brother, the parliament. Okay, please make law for us. So for that matter, Article 249. Article 312 for creating new All India service, like Indian Forest Service we created. IRMS we are creating. Yes or no? In IRMS I rechecked that day before yesterday. You were asking how many languages, but still they have not come out with it. The notification will tell that what all things will be there. Okay. Did you understand this? Now, if I talk about the second type of majority, first we reach the number, then I will tell the uses in a particular case. So what is the number here? Say for example 280 we reached here, but we have to ensure that it is half of total strength or not. The total strength here was 272. So 280 is greater than 272 or not? Answer is yes. If we might have put 400 here, we couldn't reach 272. It means the second type of spatial majority, whatever the bills are there for which this second type of spatial majority is used, could have not been passed. So what are those cases? First, Article 368, the Constitutional Amendment Act, means any of the amendment to the Constitution required this second type of spatial majority. Then apart from this, removing High Court and Supreme Court judges, second type of majority is used. Then removing of CEC and CAG, Chief Election Commissioner and Comptroller and Auditor General. I will give you the dictation. Then even for approval of the national emergency, that I told you that the higher number of people are required for approving, which is not desirable. For withdrawal we require simple majority, less number of people, because national emergency is not that desirable for people. Maybe the government has some ill intention to keep the government continue without facing election. For financial emergency, simple majority is used. You have understood this? For the approval. For disapproval, nothing. Anytime president can withdraw it, and For extension also, there is no renewal required for financial emergency. For state emergency and for national emergency, again and again renewal is required. For national emergency 1 year, for state emergency 6 months. जी जी हाई कोर्ट के जजेस को पार्लियामेंट रिमूव करती है और हाई कोर्ट के जजेस को प्रेसिडेंट अपॉइंट करता है. ओथ गवर्नर करवाता है. ओथ गवर्नर करवाता है. ठीक है. नाउ यहां तक की बात समझ में आ रही है. ये वाला जो है ना, ये बुक्स में नहीं मिलेगा आपको. दिस मिल जाए तो अच्छी बात है. मतलब मेरी बुक में मिल जाएगा, बाकी का मुझे उतना नहीं पता. नाउ थर्ड टाइप ऑफ मेजोरिटी requires 2/3 of total strength. This third type of special majority is required in president impeachment only. It is the toughest one. You can see the number. If I do 2/3 of 543, how much? Hmm? 362. Any of the number so far, you please cross check. 362, very very high number. Opposition and ruling government, all MPs together in Lok Sabha may not reach this number. Maybe in case of Modi government second time fine, but otherwise not. Did you understand? This is all type of majority. So we may have numerical also. 10 marker. Exclusive. President. Exceptional and exclusive. This is exceptional and exclusive. Because anywhere else it is not required. It is the toughest one. Oh, that is half, means that simple majority. Simple majority. So the federal matters, the article 368, yes, article 368 is required to amend the constitution. But if any federal matter, say for example schedule 7, distribution of power, the shift of subject from one list to another required, then it also require minimum half of state legislatures ratification by simple majority. That is also a case. Done. So we can write one line about it. Please write. हाँ लिख लिया. अरे अभी इसमें बहुत कुछ बचा हुआ है. Okay. Write number 1. सारा लिख लिया है. सारा लिख लिया. Everything you have noted. Everyone. Okay, चलो फिर then a new format. Please write. Simple majority is required. Simple majority is required in the following cases. In the following cases. Number 1, no confidence motion. Following cases. The number 2, confidence motion. The number 3, adjournment motion. ADJORNMENT. Adjournment motion. Then Number 4, vote of thanks. Vote of thanks. The number 5, censure motion. CENSURE. Censure motion. The number 6, election of speaker. Election of speaker and deputy speaker in Lok Sabha and Vidhan Sabha. In Lok Sabha and Vidhan Sabha. The number 7, election of deputy chairperson. Election of deputy chairperson of Rajya Sabha. Rajya Sabha. And chairman and deputy chairman of state legislative council. Chairman and deputy chairman of state legislative council means Vidhan Parishad. The number 8, approval of president rule. Approval of president rule and financial emergency. Financial emergency in both houses of parliament. In both houses of parliament. Then number 9th, the resolution passed in Lok Sabha to disapprove the continuation of national emergency. Then number 10, ratification of constitutional amendment bill for federal matters by state legislatures. Then 11th, passage of ordinary bill, money bill and financial bill. Right. So these all 11 occasions are there. Then right below this, simple majority is also called as functional majority. As government survive on such majority. Okay. Then effective majority is needed in number 1, the resolution seeking removal of vice president. Right. Then number 2, in removal of a speaker and deputy speaker in Lok Sabha and Vidhan Sabha, in Lok Sabha and Vidhan Sabha. Vidhan Sabha means Legislative Assembly. Then number 3, removal of deputy chairperson of Rajya Sabha and deputy chairman and chairman of Legislative Assembly. Legislative Assembly. Right? Then right below this, a special majority can be defined as a special majority. About special majority we have to write a special majority can be defined as a majority which is not simple, absolute or effective majority. See what a definition. Simple, absolute or effective majority. Right? It is of 3 types. So special type 1 is required in case of Article 249 and Article 312 only. The second special type is required for Article 368, then comma, for removing Supreme Court and High Court judges in Parliament, Then number 3, in removal of CEC and CAG, Then number 3, for approval of national emergency in the Parliament, right, under Article 169, for passage of resolution passed by State Legislative Assembly for creating or abolishing State Legislative Council, right? So this was the twist in the question that I asked. I used the simple majority, but it had to be a special type 2. UPSC का chairperson, Parliament will use the special majority type 2. Now what is the UPSC chairperson's equivalent position? Okay, so hence the answer. Okay. Now the third one, spatial type 3. Spatial type 3. It is the toughest, exclusive and exceptional majority. Exclusive and exceptional majority used under Article 61. Exclusive and exceptional majority used under Article 61 to impeach the president. To impeach the president. Right? Understood? Now the constitutionalism. Now before this you have to write a numerical that you can solve at home. You wrote everything here? No? Effective. Effective means total strength minus the vacant seat because of death, sickness, otherwise, or the resignation. No? No? करेक्ट होता, टेक्निकली तो करेक्ट ही होता, बट स्पिरिट वाइज करेक्ट नहीं होता, टेक्निकली तो करेक्ट होता. हाँ वही प्रीलिम्स के हिसाब से आप पूछ रहे हो तो टेक्निकली तो करेक्ट ही है, बट ये है कि एब्सोल्यूट वर्ड उन्होंने यूज किया तो करेक्ट नहीं होगा. वेयर इन पीपल से यस एब्सोल्यूट मेजोरिटी, व्हाट इज एब्सोल्यूट मेजोरिटी? नहीं होगा वही. People get confused in case of Article 249 and 312. There's a catch. It's a catch. So numerical, did you understand? You understood? No? So I have the numerical for you. Caution. Lok Sabha, total strength 543. Vacant seats 23. Present 500. Voting 450. Number of Vidhan Sabhas in India 31. You need to tell me simple majority. You need to tell me special majority type 1, type 2, type 3, absolute majority, effective majority. Any other majority? Any other majority left? Nothing left? This is the numerical, please solve it, you will have more clarity. So far we have solved 3 to 4 numericals in class, no? For different topics. For Legislative Council. हो गया? Yeah. Done. What is the answer? Simple majority. 2 2 226. Okay. For a special type 1, hmm? 300. Okay. And hmm? Same. And 362. And absolute majority 272. Effective majority 261. Any of the mismatch? No mismatch? All are agreeing to? Any doubt? No doubt? Okay. Redo it at home. Come back to me if any doubt is there. इसके बाद सेपरेशन ऑफ पावर. Constitutionalism. So what is constitutionalism? Okay, you are saying constitution is father, supreme. Parliament is daughter. Okay, parliament is daughter, secondary. In the patriarchal society, not in the matriarchal one. Right? Constitutionalism. Any other thing? Huh? Guiding principle. Guiding principle. And any other thing? Written document. Rule of law. No absolute power. My question is, we can have constitutionalism without having constitution. No, it takes two to make quarrel, or there may be a sound by using only one palm. No, it takes two to make quarrel means एक हाथ से ताली नहीं बजती in English. Okay, एक हाथ से ताली नहीं बजती means two palms are required to make sound. Yes or no? So if I say that, yeah, without having a constitution, we can have constitutionalism. So in monarchy, can we have constitution? Sorry, constitutionalism. So that is what I am asking. That what is constitutionalism then? Is philosophy, is a concept, is a legal concept? What is it? Is it all about? Is a philosophy. So in prelims, if there is a question, constitutionalism means A, B, C, D. Rule of law, supremacy of the constitution, limited government, and written document. So either of them is correct. Rule of law. Rule of law. Easy question or not? Yeah. Limited government is the answer. This question has been asked in prelims. This question has been asked in prelims. Limited government means simply what? If we are creating something, God has created this world. If the God is not having Godism, then this world is not a limited world. Because we are not able to make blood till now, till date. Because we are not able to make massless particles. We are not able to understand the real cause of earth gravity or magnetism. We are not able to understand what is there after universe. And we never know that what will happen next. Okay, so that's how the constitution that has created the organ, but constitution is having its control on it, is called as constitutionalism. It's called as constitutionalism. So constitution itself is controlling its organ, or it is getting it controlled, getting the organs controlled by one of the organs sometimes. Say for example, Supreme Court is controlling the government by way of judicial activism and interpretations. The liberal interpretations by judiciary is anti-constitutionalism or constitutionalism. Interpretation is constitutionalism. More of judicial activism may be anti-constitutionalism. Yes or no? Now, doctrine of checks and balance is part of constitutionalism. Yes. Doctrine of checks and balance is complementary part of separation of power. Separation of power means all organs are working, but there are transgressional areas, gray areas, wherein objective definition is not there, that wherein this function is falling, and jointly it is being looked after. Yes or no? If the home is being run smoothly, we cannot say that because of only one person this house is being run smoothly. It's a joint effort. It's a joint effort. So what effort you are giving in yeah. So if you are not in house, you are contributing for the house peace. If the children have been sent to the school or college, it means okay, everything is fine. That's how it is. Okay, so constitutionalism is a philosophy, and constitutionalism is not a product. It is a process. It is not a prerequisite that you have set the rules before you are starting your game. Once you have started the game, then only constitutionalism you can realize. But it is not that okay, we will be meeting this constitutionalism in this quantity and at a definite place. No, it's not. You don't understand this? Now, democracy, sovereignty, rule of law, the conventions and the interpretations. Conventions and interpretations, the code of honors, these are not lesser than the constitutional text. But because no constitution can be the perfect or a full length text can visualize all possible future situations, so the code of honors are developed because of the practical gaps that are coming in a particular case, and we are filling those cases by having kind of natural force, naturally accepted act. They become the code of honor, the conventions. You are getting my point? So there are many conventions in our parliament. Nowhere it is written that after losing election the present government will be resigning in the parliament. Not written, but it is a convention. Nowhere it is written that a speaker will be from ruling party and the opposition will be providing then the deputy speaker. It is a convention just to balance the neutrality in the parliament. That's how it is. Because speakers, sometimes one will be falling sick, then deputy speaker immediately will come. Deputy speaker is from opposition, will settle all the score in one day only. As far as ruling party is concerned. Yes or no? Yes. No, means Lok Sabha has its own rules. The ruling party cannot do anything, cannot dictate its terms. It may rule, it may walk out, then other people will decide. At least they will be making hue and cry in Lok Sabha TV media. Then, if Congress is giving 100 crore rupees to a media to just repeatedly showing a particular clip of a particular day, then what is the problem? It can mind washing, brainwashing. Yes or no? This is voting behavior influence. Now, the constitutionalism is also based on Magna Carta, brought in 1215 AD. What is Magna Carta? Magna Carta simply means what? Magna, magnify, magnified, bigger one. Magna, as the name suggests, big. Carta means cart, C-A-R-T. You are putting something in the basket. Magna Carta, big basket. Right? Big document, lengthy document, marathon document, base document. British Constitution, this Magna Carta is all about. And against this Magna Carta, US brought Bill of Rights. Not in the original Constitution. After the Constitution was brought. Right? Now, closely connected to this constitutionalism is separation of power given by Montesquieu, French scholar. Though it has been originated by Aristotle, mind it. Separation of power for the first time was visualized by whom? Aristotle. But it has been championed by Montesquieu. Now Montesquieu was motivated by whom? By what concept? By what constitution? US also. US also. Even the French Constitution influenced the idea of separation of power given by Montesquieu. Now, what the separation of power is all about? What do you mean by separation of power? What all things are required? Is that it? Is it that it is easy? तो फिर number one, the body is to be separate. Number one, in that body, the occupant should be separate. It is also a possibility that occupants are same. Then work is also separate. The functional separation is also very, very important. Then there is a separate agency to appoint them. That is what separation of power means. Means complete separation. So for example, the family member, living in one house and one room has been given on rent, or one floor of the house has been given on rent. So occupants are mixed. It is not separation of power. Privacy, invasion of privacy, at least some that you are accepting it that way. Yes or no? As far as civilization, artificial civilization is concerned, in the family, you will not be making noise if you need to be an example of decency. Yes or no? Separation of power compromised. Then the work separate work. Separate work means what? Judiciary is busy in deciding the cases, not in governing the country. But judicial activism is a compromise on the part of separation of power. Yes, it is. Yes or no? Judicial activism means taking up the executive role. Then separate appointments. So now NJAC that is coming up again is a compromise on SOP or not? Because Law Commission is coming in picture. Then in Indian democracy, separation of power, Article 50 provides only for 33.3% separation between executive and judiciary. Though separation between legislature and judiciary, sorry, the confused. Separation between executive and judiciary has been provided by Article 50. Then between judiciary and legislature, and between legislature and executive, between the judiciary and legislature between executive, the separation was enhanced by making an amendment to CRPC in 1972. CRPC 1972, when the police was not allowed to have its magistrate power, or you can say the administration also. Firing orders as well as the magistrate power of an IAS. CRPC 1972. So it was complementing Article 50, but CRPC is not a constitution. It is a British legacy. CPC is a British legacy. Yes or no? IPC is a British legacy. 1860, 1872, Indian Evidence Act, British legacy. Thanks to Raja Ram Mohan Roy and Macaulay also to an extent. Benevolent despotism. Yes or no? What do we mean by benevolent despotism? Colorable legislation is also benevolent despotism or not? Yes, to an extent. So can we write one line about it? Okay, please write. Constitutionalism envisages ENVISAGES checks and balance and puts power of legislature and executive under some restraint, 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 comma, otherwise freedom of people would be in trouble leading to authoritarian government. Authoritarian government which are of anti-constitutionalism in nature. Which are of anti-constitutionalism in nature. As more political corruption, more colorable legislation, are seen. Full stop. So without genuine democracy, constitutionalism cannot be a reality. Full stop. Free and fair election, and freedom of speech ensures arrival of constitutionalism, or onset of constitutionalism. Following constituents are important to have constitutionalism. That is liberal interpretation by judiciary, then rule of law, then separation of power, then conventions, that is customs, maxims, and precept, P-R-E-C-E-P-T. Precept in English means standard minimum level of something. P-R-E-C-E-P-T, precept. Then sovereignty, then last a law in monarchy or constitution. Then right below this, perhaps Magna Carta, M-A-G-N-A, Magna Carta, C-A-R-T-A, Magna Carta of 1215 AD, Anno Domino AD, is the earliest document of British Constitution, wherein the institutional and intellectual framework was visualized to have theatrical currency, theater, THEATRICAL, theatrical currency with which political transactions are carried on. Political transactions are carried on. Full stop. A country may have constitution, theatrical. Theater means you are orchestrating the activities, political activities. Theater, wherein some performance is going on. So when you are putting the actors in picture, so actors means here parliamentarian, the legislators, and they are giving the required performance. So it is a theater. It is just an expression, nothing else, right? A country may have constitution, without having constitutionalism, For example, Pakistan under military dictators. Right. Then right below this, UK is a constitutional monarchy. UK is a constitutional monarchy. Has constitutionalism. Has constitutionalism. Has constitutionalism. So is Bhutan. So is Bhutan as pure monarchy. As pure monarchy. Has constitutionalism. Has constitutionalism in its administration. In its administration. Full stop. So it is a philosophy. So it is a philosophy and not a legal frame. Not a legal frame. Okay. So constitutionalism is a philosophy, not a legal frame. It means constitution is not there at all. Then also you can realize constitutionalism. So is Ram Rajya. We have a law in monarchy also. Administration is there in monarchy also. The courts are there in Bhutan. They are working. Constitution is not there. Right? Law can be there without constitution. Law doesn't mean a constitution. Simply. So in Bhutan, laws are there. Police is functioning. Recruitments are on. Uniform is there. It is a country. And country, a separate definition is there. Yes or no? And a country, if it is accepted by United Nations, then you are a state. And a state means you are having a definite boundary, and there is a legal frame which is running the definite boundary. Maybe the constitution is not there, but it's a legal frame which is there in your country. Okay? Did you understand what did I say? So that's how it is. As simple as that. Please write separation of power. Write in it. Though the earliest proponent Though the earliest proponent of SOP is Aristotle, but but Baron de Montesquieu, Baron, Baron space D Montesquieu, Montes Quieu, Montesquieu made it a real concept in his book Spirit of Laws 1748. He was motivated by British and Roman constitution mainly to design his SOP, which means number one, separate body, number two, separate occupants, then number three, separate work, then number four, separate appointments, right? Then right below this, in India, Article 122 and 212, which are for the fact that legislative proceedings cannot be questioned in court, reflect SOP. Further, Article 121 and 211 says that judicial conduct cannot be discussed in Parliament, reflect SOP. Right? Then right ahead of this, below this, USA became the first country to incorporate SOP in the written constitution. Full stop. Since US Constitution provides presidential form of government, the executive and legislature separate itself completely. Executive and legislature separate themselves completely. I repeat, since US Constitution provide presidential form of government, the executive and legislature separate themselves completely, right? However, such SOP is not a watertight compartmentalization, watertight compartmentalization, as as there are certain common areas, of operations operations among the three organs of the government. Further, SOP has been modified. By doctrine of checks and balance in most of the countries, including India, wherein Article 50 provides for SOP only between executive and judiciary. Only this, executive and judiciary, which is only 33.3% SOP. The Parliament enacted CRPC in 1972 to separate certain what did you write? CRPC 1972 to amend oblique enact कर सकते हैं, amend, enacted part of CRPC in 1972 which separated or to separate certain executive and legislative powers exercised by executive magistrate in 1996. Supreme Court in Kannadan case, KANNADAN, Kannadan case, gave doctrine of checks and balance. Right. To make the bylaws for ordering the arrest, to interpret the raid kind of activities. Bylaws are means when we will be studying about delegated legislations are exercised by the administration only. This is something which is the necessity that legislature cannot make every law. every possible merit law. So MCD here in Delhi, so police also, they are making the laws. This is delegated legislation, the fourth branch. So this is what we have for separation of power. Now if we have a prelims question in separation of power, what can be there? Consider the following. Very easy question is coming ahead. A for assertion. A for assertion and R for reason. R for reason. Then A option is saying that A and R both are correct and A is explained by R. And you know A and R both are correct, but there is no connection in between these two. Then C, A is right, R is wrong, and D, A is wrong and R is right. Okay, so the question is separation of power is necessarily found in US Constitution. In US Constitution. US has all three organs created by a written constitution, WR means written constitution, namely legislature, executive and judiciary. What is the answer? B? No? Confused? If you are confused, then use a formula. I eat, I feel hungry. So you are. Right? So I eat because I feel hungry. If it has to be A and if it has to be B, sorry, R, it cannot be the A answer. I feel hungry because I eat. No. So if the second is connected with the first one with that's by, then first can be connected with the second one with because. Conjunctions. So that's why it should be in reverse if it is to be with because in the forward connection. Yes or no? So it is connected with this, with that's why or because. That's why. I feel hungry. That's why I eat. I eat because I feel hungry. Simple. So this is the formula. So here answer will be B, because separation of power is necessarily found in US Constitution. US is having all the three organs. So is the case of UK. But separation of power is not there. Now if I just twist the question and I write here . separation of power is not found in UK constitution fully. Then second is independent judiciary is not the feature of UK or in UK. What is the answer? Water. Separation of power is not found in UK constitution fully. That's correct. UK is having a constitution but not written. But independent judiciary is exclusive feature of UK, not of US. Independent judiciary is a feature of in UK. Judicial review is feature of US. In UK, centralization, not decentralization, is there of power. So that is why separation of power is not completely found. Independent judiciary, UK is the flag bearer of this concept, giving motivation to other countries including US that have independency in judiciary including India. But judicial review is part of US. Okay. Little things. So these are not there in books. That is why I am just explaining it. Here, of course, the answer is that it is wrong. Then C is the answer. Okay. So, where were we? Any other concept in that list? Oh, and administrative systems. So it is a big concept. So comparison among constitutions and administrative systems. So administrative system is exclusively in paper 1, right? So we'll be understanding this separation of power also. If we are able to understand comparisons, then only it is understood fully. So we can start it. क्या हुआ? अच्छा ब्रेक. अच्छा. So in comparison of the constitution, the houses there in US and here in India. So in the lower house we are having 435 seats in US and here in India 543, and in upper house we have 245 seats, but in US there are 100 seats, and apart from this there are 3 seats in US through nomination coming only from one state, that is Washington DC, District of Columbia, right? So making a total of how many seats? 538. Sorry, we're making a total of 538. Yeah. Okay. But here the tenure is of 5 years, here the tenure is of 2 years in the lower house. In the upper house the tenure is of 6 years. In the legislature, wherein it is called as parliament, herein it is called as Congress, president is not part of the Congress, whereas here president is integral part of the legislature. Means same thing, legislature here, but here the name is Congress, here the name is Parliament. Okay. Now the president here can be elected as president for a maximum terms of 4 years into 2, that is 8 years, and one has to be naturally born US citizen. It means naturalized citizen cannot become the US president. Naturalized citizen means if a foreigner living in US for certain number of years and claiming citizenship, and one has been given US citizenship, then one will be not the aboriginal US citizen but naturalized US citizen. Naturalized means one has come a long way, residing in one country, language, the culture, one is able to identify himself or herself with the crowd. Identical one has become. Okay. So naturalized citizen is not allowed to contest president election, but here in India naturalized and everyone, and for a number of years. But there is a convention developed in India that more than twice one should not be elected as president. This convention was because of Dr. Rajendra Prasad and Jawaharlal Nehruji, that Jawaharlal Nehruji did not want him to be president for the 3rd term. That is why it was not done, though he was willing to be president in the 3rd term, but it did not happen. Okay. So, and then here the term is of 5 years. This is kind of factual comparison is there. But if you talk about the constitution in India, it is supreme and parliament is secondary. In US the constitution is supreme, then the Congress is not secondary. It is the president who is secondary, right? Whereas in India it is the legislature which is secondary. This is the difference. In case of UK, the parliament is supreme, whereas constitution is secondary, because in UK written constitution is not there. Written constitution is not there. Okay. So this brings us to the fundamentals practiced in the constitution. First we will be discussing the connection of Indian constitution with that of UK as well as US. Then maybe with France, Japan, right, Australia, then their administrative systems. Now, if we talk about the cardinal principles, means the guiding principles in the constitution. So, you know something called as due process of law. Then there is something called as procedure established by law. What is the difference between these two? You know it. Hmm. अच्छा. बोलो. If it is the difference, then what is the difference between equality before law and equal protection of law? Now you are saying, oh, गड़बड़ हो गया. You know what you were saying was of this, not was of this. What did you say? Equity and equality. Mhm. Hmm. Ah. Hmm. Procedure established by law has been borrowed in Indian constitution from which country? An equal protection of law? Hmm. This is from Japan. Okay, procedure established by law. But of course, the thing is coming from UK. Due process of law is followed in USA. It is printed in our Article 21, procedure established by law. When you were taking dictation for death penalty, Article 21 deprives someone of his life in accordance with procedure established by law that you have written today. So I tell you, this is legislature. Yes or no? So legislature here has made the rule that ORN occupants, the residents as of now, old Rajendra Nagar, right? The law is there. They will be contributing for planting and cleaning the street as part of the demonstration that India is thriving every day 2 hours in the morning. This is the law. Yes or no? Law is law. Now you guys are busy into something else, preparation. Up till 2 o'clock you are studying and you are getting up late, maybe 10 o'clock, 1 hour before the class. Yes or no? So you are just very much offended and you went to judiciary that this law has been made that for daily 2 hours in old Rajendra Nagar we will be on the cleaning drive. It is not fair. Challenged. that this is unconstitutional. It is going against our Article 19 and Article 21. Then judiciary, by employing this, will be able to examine only that law has been passed by following a correct method or not. That the simple majority or the special majority which was required by the constitution in passing that law has been followed or not. That's it. It means the judiciary cannot get into the content written in that law. Now the police was authorized to apply such law in Old Rajendra Nagar. So in every PG and rooms, police was checking that no one is sleeping and everyone is on 2 hours drive. Now in the police, the people were arbitrarily, you can say, following that law, come what may. One person was very sick, but no, you have to be on cleaning drive. Now such forceful act of the police will be examined by the judiciary. It means by employing this expression, judiciary can give you protection from arbitrary action of the executive, the police, right? Then also from judiciary only from the fact that the correct methodology has been followed or not. It means judiciary is blindly believing into the wisdom of the legislature, and legislature is miniature nation. So judiciary is actually believing in the spirit of the nation, because you guys have elected number of people, the parliamentarian, and they have made the law on behalf of you. Actually you are making the law for yourself. This is what democracy is. So judiciary is believing you guys blindly. But this protection is complete protection or partial protection? It is partial protection. Now it was improved upon in due process of law, and this was incorporated in 1978 in Maneka Gandhi case, that if any law is to be examined for its constitutionality, fully or part of that law, means part of that law may be unconstitutional or part of rest of the part may be constitutional, but to the extent it is fine, we will be upholding it, otherwise we will be declaring it as null and void ab initio and unconstitutional. Yes or no? Null and void means ineffective. We will not allow it, we will not apply it. So judiciary is giving complete protection by employing due process of law, that not only the process that you have followed in passage while passing a law, but also the content of the law we can examine, that what is written in it. So they will be saying that it is a voluntary work. Who is voluntary will come for the cleaning drive, other person is not voluntary, is not coming. You cannot force. Like it is a blood donation work, voluntary person is coming ahead, other person is not going. Simple. No one is forcing that no, you have to give the blood in blood bank parked in the ambulance here next to this building, and you are walking on the road and 2 police people are taking you inside the ambulance. Lagao that syringe. So not possible. So population control in 1970s by Sanjay Gandhi. Yes or no? So arbitrary measure not accepted. Acceptance has to be there in any policy, be it control of population, right? So that's how it is. So if I say that executive protection, legislative protection, both are possible by way of due process of law, so as to have fair, just and reasonable law, not arbitrary, not forceful, not fanciful, not colorful, not oppressive law. This is the fundamental difference between these two concepts. It will come again, right? And when we say that equality before law and equal protection of law, then equal protection of law is belonging to which country primarily? US. And equality before law? UK. Equality before law is a negative concept, positive concept. Negative because of Article 361, and it is based on what? Rule of law. Rule of law was given by A.V. Dicey. Yes or no? Now what this equality before law is saying? That if you are standing in a court and two people are to be examined, they are of equal age, both are 18-year-old, both are 18-year-old, they are to be examined. So one is VIP, affluent class, elite class, and another is poor UPSC aspirant. As far as physiological strength is concerned, it will be draining day by day. Of course, for time being it will be. Yes or no? So that is why some little exercise within room it is important. No? Yeah. So coming ahead. Now if the judiciary is examining these two people, then if one is VIP, one is of affluent class, will be given VIP treatment. The one is not, will not be given. Then what will happen? It is not to be there, but it is negative because of Article 361 here. Why? Because President and Governor are given the immunity that civil case cannot be registered against them while they are in office before the expiry of 2 months notice, and criminal proceedings cannot be instituted against them while they are in office. While they are in office doesn't mean that they are in office in daytime and in night they are when sleeping we can register case against them. No. While they are in office means tenure, 5 years tenure. After that only the criminal proceedings can be instituted. Criminal proceedings means what? In personal capacity, if president has murdered someone, then we cannot do anything. In official capacity, mercy petition was there, one has rejected it, or many other work are there like arbitrary suspension of a bureaucrat, dismissal was also granted by the president. So these are the mistakes for which president is not directly responsible. President is there to get the work done, not to do the work, but still president on the moral ground can be held responsible. So for such questions, so far we have not seen such things. If in future certain cases are noticed, we will come back to you. So that is why we are not doing it. We are not electing such a person who is, yeah. So when we talk about the president election, you see round of the elections and the nomination for the president election. So definitely people are seeing, media is seeing, they are digging deep into the history of a person who is to be elected as president. Yes or no? So one has come a long way, and we know that what all is possible in future. Limited future, all means old age. A future of 10-15 years, that's it. All the meaningful year already gone by. So this is what is the case. Now equal protection of law is based on principle of natural justice, right? Now equal protection of law says what? If they are standing outside the court and if they are to be discriminated against each other as far as the positive reasons are concerned, then they can be. So if they are two brothers and mother has to give them some food, whom mother will be giving more, will like to give more. What I would say to the UPSC aspirant. Okay, so that's what I'm saying. So here the positive discrimination, if one is outside the court, then the jack effect is there. Okay, jack effect is there. So that's how it is. This jack effect is called as positive discrimination or affirmative action or reservation in India, and it is part of equity. Equity simply means making unequal people equal. So the reservation is, that is why, so that's what is fine, good to go. They are parents, you guys are individual, so you are right as per your individuality, they are also correct as per their parenthood. Yes or no? It happens that way. So I know one of the parent who are into the civil service, two sisters, one brother. Elder sister was guiding younger one. She became an IAS. Elder sister was giving exam repeatedly. All exams exhausted, all options have exhausted. So this is life. Now parents are correct as per their parenthoodness that they have to give. Individuals are also correct. So sometimes, life is like this. Yeah, Serena Williams and Venus Williams. Game is game. So they might have decided at home that okay, this is a legitimate fixing wherein no one can do anything. And if betting is going on for that these two sisters may become billionaire also. Betting, fixing. Here no court can do anything. Obvious reason, right? So that's how the conceptual difference is. Now, up till this point, should we write something or we should discuss? Not right. No, I will give you what I feel that total 9-10 pages are there. It is, some student wrote it, my dictation, and I had a copy of it, the management, so I'll the scanned copy. कौन से वाले? Okay. अच्छा, मतलब it is it's a sarcastic behavior that no we have to put ourselves there or or not. I mean, effort wise. No, I'm just favoring you guys. That's what is the case. 9 pages, I don't have any problem. I can give you the dictation. Hmm? Okay, what is the Panchayati Raj institution called in US? No, local self government or Panchayati Raj institutions. County. No, that is a different case, but counties are the smallest political unit in US. Here in India, district are the smallest political unit, not the village even. Political unit means unit, but political unit also. Yeah, panchayat, but not the village. Hmm. So how many panchayats are there in India? Okay, now I'm just discussing in general. Here in India, 1st April is the first date of financial year. In US, what is the first date? Hmm. No, no, no. It's 1st July, 30th June, the last date, right? Now, in India, there is a budget speech either given by finance minister or by PM. PM being finance minister, keeping the finance ministry with him. But is there any budget speech in US? Hmm? No, it is not. Even president cannot give budget speech. It is not their separation. And who will give the speech in Congress? That is a matter. Now, in India, if a veto is applied by the president for simple, for ordinary bill, absolute veto means the bill is dead, bill is no more. But is the same case in US? No. There is something called as qualified veto. Decide. Decide basically the demands are going from every department. Departments mean the ministries are called as department there and US. And the Congress is making, the Congress means the legislature is making the demand approved because the voting is going on. Votes are given to pass a budget. But there is no speech, budget speech in US. So finance secretary is securing the cooperation from the departments. From the other departments, they are asking that what all amount you require for the next years. Before compilation means all these departments will be reporting to the president of secretariat, and then they will be giving the demand to the Congress. Then Congress, after getting it approved from both the houses, right, then the amount will be withdrawn from the fund will be kept with the treasury. Then fund means the largest fund there, right? No, Qualified veto. Qualified veto means if the president has declined to give approval, then the Congress can dominate president's veto. Right? The relative higher number for 2 by 3 is 3 by 4. Of present and voting. Of present and voting. Right? This is the difference. Qualified veto is not there in India. What is facelessness in US? बोलो. Facelessness. Yesterday I told you about this. Facelessness is a temporary college for electing the president, and this college is constituted to elect the president, and after this it is disbanded. In facelessness, against the 538 members of Congress, new 538 people are sent from respective states. So they are having different face, but their representatives are there as part of this temporary college who will be voting for either of the candidate, presidential candidate. Two candidates are there. Presidential candidate from two political parties. So 538, so more than 50%. More than 50% should be there with either of the candidate. Right? No? No, randomly not. In states there are elections. So for example, there are 50 states. So say for example like this, and in one state they will be having elections and they will decide to send one of the candidate, either from Democratic or from Republic. That's right. Now this facelessness is becoming sometimes disloyal factor. When a person is giving vote in center for this, maybe he is from Republic and one is giving vote for a Democrat, or vice versa. It is possible. Vote is secret. Vote is secret. Right? This is the kind of facelessness demerit. But we have not means they have not replaced it so far. So for example, there are two candidates in the state. These two parties had an election. Democrats won. In center, the voting will be there of all 538 people sent from 50 states. A person who is from Democrat voted for a candidate who was supported from Republican side. This is double facelessness. So this is a demerit, but we cannot do any, means they cannot do anything. They have not replaced it so far. They can't figure it out. So people say that it is direct, but it is indirect. Okay. So now लिखना शुरू करना था, but anyway क्या करें? अरे अभी तो बहुत है. US, then UK, then Japan, then Australia. Okay, this document we send it to you. Okay, you read it here or you read at home. Fine. There's one document. I'll send it. Huh? Death penalty आ गया. Okay. This handwriting. This is the one. It is not of mine. If anything is there, but yeah, handwriting is fine. That's how it is. Because things may vary in every dictation, right? But if I find some of the writings good, so it become a kind of standby option in some of the cases. So let's wind it up, because when I was discussing, I was seeing your faces. So some people were in some other world. That is why it will defeat the very purpose of the class. Oh, some people may comprehend, otherwise some may not. Right. This is the basic scenario. So we'll meet tomorrow. Fine. Congress means legislature. The yeah, representative, HOR, House of Representatives. Upper house को Senate. House of Common and House of Lord in UK. Means? No. Vice President is the discretion of the President to have one person as Vice President or not. It is not compulsory to have Vice President. Many people? Okay. Why? Personality. Maybe the yeah, temperament. Because they were in want of a good leader, but only two people whom to choose. Then very thin margin between two it was there in case of Donald Trump. Yeah. They are all yes. Yeah. That because anthropological loop. I told you, these are all rascals who are there in the US bloodline wise. All the miscreants, all the prisoners, the habitual offenders who were enjoying the jail life there in UK were sent to a barren island which is there as North America today. And they left them free. Why? Because aboriginals in North America today were also of that nature, the tribals, and these miscreants who were habitual of doing murder and all, killing the people, were left free there in that island, and they finished lakhs of the tribals there in North America today. And then they started making up their own system, and this is US today. And basically Europe, stability factor is because it is not surrounded by many big countries, is relatively falling apart from geography wise. That is why it is relatively more stable. People like to live life peacefully, and quality should be more. This is what European as far as North Europe is concerned. So people were happy celebrating Diwali when there was terror attack in some of the European countries. You see the history. After Hitler episode, it was relatively at peace. Because of Hitler, there was some disturbance, and Hitler was himself a psychopath because of some personal factors. Mein Kampf, if you read. Okay, so for personal revenge you should not put the state at the stake. Okay, हाँ नहीं अभी नहीं, after selection, after selection. So see you tomorrow.